Hello everybody, Martin Radner here from Radner Law Group bringing you trial analysis. Today we're going to be discussing more about the Jessy Kurczewski murder trial. This is also referred to as the eye drop murder trial, where there's a few questions in this case. Number one, what did Lynn Herndon actually die from? Was it from the eye drops, the Visine, the tetrahydrozoline poisoning? Was it that? Or was it from some of the other 20 to 30 prescription pills that were in her system at the time when she died? It took the medical examiner months to come to her conclusion that she actually died from tetrahydrozoline poisoning, and it also took months for her to come to the conclusion that this was actually a murder as opposed to a suicide. So the defense is going to be arguing on both sides. Number one, it really wasn't tetrahydrozoline poisoning, and number two, they can't prove that it was a murder as opposed to a suicide. And we spoke about this, the theories of the case on both sides in previous videos. Please go ahead and check that out, and you'll get a good full analysis about this trial. But something happened during this trial which is interesting, and it's really an interesting topic in the first place, and I think that a lot of people that aren't lawyers are not going to appreciate exactly what's going on here. So let me play the clip for you first, and then we'll jump into the explanation of exactly what's going on and who's right, and was the judge right for screaming at the attorneys or not. But this was a case where the clip that we're about to see, the judge admonished and screamed at the attorneys for doing something, and we're going to explain everything that's going on with this. Please, before we do, subscribe if you haven't yet, like the video so we can continue growing and bringing more people to this analysis. All right, without any further ado, here is the clip.
Mr. Spiller, your CV is 44 pages long, right?
Yes.
There's dozens and dozens of articles, more than 100, maybe 200 articles that I didn't show the jury today, right?
It's about 220.
Okay, we didn't. And it's fair to say during the break, despite Attorney Nikolai's suggestion that I showed you some article about, what was this article about? Because I've never even seen that article. Acetaminophen or something like that?
Tizanidine? No, I don't know.
I didn't show you any article about that during the break, did I? About acetaminophen.
Oh,
I'm saying that I didn't show you this article that she's talking about during the break.
okay. Yeah,
True.
I think we're talking about the difference in acetaminophen, aspirin, and ibuprofen.
Right.
Is that what we're talking about?
That's right. I'm just saying I didn't show you that. We didn't talk about that during the break.
No.
Objection. This was entered by defense as Exhibit 626.
That's not the question. The insinuation was that
Hold on. Stop. I'm excusing the jury. Be seated. I'm warning both sides. Stop with the speaking objections. It needs to stop now.
Okay, so let's set the background for what exactly happened before this clip. So you've got this expert who's testifying. Now this expert, as we've, just from this small clip, we can tell that this is a very, very specialized expert. This is a very good expert, and you know, when we talk about CV is another word for curriculum vitae. It's essentially a resume. It's a resume that experts, instead of calling it a resume, they call it a CV. And you know, for the rest of us, we have a CV that's maybe 1 page, 2 page. This expert has a 40-page CV, which means when he has to list all of his accomplishments and all of his publications and all of his accolades, it takes him 40 pages to be able to put them all together. So it's a book. He has basically a book for all of his accomplishments that he's done, all his education, all of his speaking engagements, things like that. So it's just, you're obviously dealing with a renowned, specialized expert. And on top of that, it seems like he's written over 200 articles. So he's certainly knows what he's doing. He's a big expert, and there's a whole different analysis about how to deal with experts like this. How do you win the expert over to your side? Well, how do you punch holes in this type of expert? That's all about trial advocacy. It has nothing to do with what really we're going to be discussing today. What we're discussing today is really more about what the judge's interactions with the attorneys, and because she obviously admonished both of the attorneys in this case. So, okay, just to set the stage for what happened here. So, it appears that during the prosecution's cross-examination of this witness, the prosecution suggested that the defense showed an article. This testimony was taken after the lunch break, right? So they had a lunch break. Now you got this expert back on the stand, and the prosecution says, now this article you discussed, or suggested that he discussed it with the defense counsel over lunch. This article that I'm about to ask you questions on, and then she continued to ask questions on that article. So, as a lawyer, when you're in front of a jury, you don't want the jury to think that you're acting in a way that's improper. And you don't want them to think that you're trying to bend the rules or trying to do something sneaky. A very big part of being a lawyer is, especially during a trial, is to let the jury know that you're transparent, you're the good guy, and the other side are the bad guys. And that's what the other side's trying to do to you. You know, the other attorneys are trying to paint you like a liar and paint you like you're acting improper. So there's a lot of these little tricks and little arguments and comments that you can make in front of the jury to try to win the jury over to your side. So it may seem like you're just asking a question, but you may throw in a few words to try to win the jury over to your side, to make them understand that really you're the good guy and the other side is the bad guy. So by the prosecution asking a question about this article, and she just happens to mention, this article that you're just looking at with defense counsel over lunch. So let me ask you some questions about that article. So even though it looks like she's just asking a question about the article, really she's throwing in there this comment about how you were looking this over with the defense attorney during the lunch break. And that can resonate with the jury. The jury can be thinking about that and saying, hey, they're getting together over lunch to try to figure out how to win their case. And really, the jury just wants things to be open and honest, and not that you're trying to do anything sneaky with your witnesses during the lunch break. So that's something that the prosecution mentioned during their cross-examination. So the defense attorney right away gets up and she wants to dispel this notion that she's doing anything wrong. She doesn't want the jury to think that she's doing anything nefarious. So therefore, the second that she gets up to redirect, it's called, so she tells this witness, she says, we didn't speak about this article during lunch, did we? And in fact, what's this article even about? And right away, the defense attorney jumps up and says, you can't argue that she objects. The prosecutor jumps up and objects and says, this is an exhibit. This is an admitted exhibit. You admitted this article as an exhibit. How can you now pretend like you don't know what's going on with this article? And how can you pretend that you didn't speak about it during lunch? And the defense attorney says back, that wasn't my question. My question was, did we speak about this article over lunch? And right away, so the judge excuses the jury, and she admonishes both sides for speaking objections. Now, what are speaking objections? Okay, so objections really, when an attorney makes an objection, there has to be a rule that you're objecting under. You can't just say objection for no reason. You've got to have a basis for your objection. You don't like the question? Well, too bad you don't like the question. There's got to be some sort of basis to give the judge. And that's, again, like we always talk about, one of the main jobs of a lawyer is you have to provide the court with authority why what you're saying is correct. So you have to research the law. You have to be very well-read and understand the rules of evidence and the court rules and other rules that are associated with the jurisdiction, whatever they are. You've got to be familiar with them because you're the one ultimately that has to give the judge the reason, the basis why she should rule in your favor. So when you're making an objection, it has to be based on a specific rule. Now, when I was in law school, I was taught evidence by a federal judge. So the federal judge, during his classes of evidence, he'd always talk about the trials that he was in, and he would talk about the objections. And that was an important part because as the rules of evidence, there's going to be a lot of objections based on the rules of evidence. And one of the things that he said, this was his specific preference, he said that when you object in my courtroom, the only thing that I want you to say is you're supposed to cite to the rule of evidence. So if you make an objection, your objection should sound like this: objection 901, objection 803, objection 401, 403, objection 505. That's how he wants you to make an objection. And he says, I know the rules of evidence very well. I've been doing this for a long time. I know the rules of evidence. And if you tell me a certain rule number, then I'm going to know what your objection is based on, and I'll be able to make a decision based on your objection and citing the exact rule. I don't need you to say anything more. And in fact, I'm not going to let you say anything more, because when you say more as an attorney, what are you trying to do? Why are you saying more about your objection? So number one is because a lot of attorneys don't actually know the rule number. So they know that there's this, let's say let's do an obvious one, right? So this evidence is not relevant. So that's an obvious one, but they don't know specifically what rule is that. Is that 401? Is that 402? Is that 403? They forgot exactly which number that is. So they'll say objection relevance, or they'll say, let's say hearsay, objection hearsay. And everyone knows the hearsay objection, but they could be that they just don't know the actual rule number. So that's why they may actually not just say the rule number, they may actually say the actual the rule as a statement, as what the words are: relevancy, hearsay, authentication, things like that. So that's another reason why lawyers may say more than just the rule number. Now, the next part is when you may not know the exact terminology for what you're objecting to, but you know the idea. You know something sounds wrong here. You know as an attorney this is improper, and therefore you want to explain to the judge why it's improper. So you tell the judge, like in this situation, objection, this is an admitted exhibit, and therefore you can't pretend that you don't know about this exhibit. This isn't your exhibit. So what rule does that fall under? What number does it fall under? It's not so clear. So you want, as an attorney, you still want to preserve the record, and therefore you're going to say this objection, and you're going to try to explain it to the judge so the judge understands. Now, there are certain times where the judges are not like this federal judge who taught me evidence. There's some judges that actually don't know the rules that well. They don't know the rules of evidence, and they don't know the court rules. And if you just say a rule number, they may actually not know themselves what you're talking about. And it may look embarrassing for them if you just say objection 505, and they're going to have to start looking through the rules of evidence to see what you're referring to. So therefore, as an attorney also, you may want to just explain your objection to the judge. So you won't have to take a break and make him look silly or her silly. So you'll just say, objection, this is hearsay, and not within any exception. And if the other side has to say, well, there is an exception to this rule, and the exception is the following. So you explain it to the judge. So that's also another reason why you may want to have more of a speaking objection. But this is where attorneys love to push the line. The question always is, as an attorney, how much should you push the line? How much should you push it? Should you just say exactly what you need to preserve the record? That's important. You have to preserve the record in case this goes up in appeal. The appellate court has to see where your objection was and what the basis for your objection was, and then they'll be able to rule whether the judge made the correct ruling in that objection. But the attorneys also want to win the case. They want to win the case, and they want to win. Part of that is winning the jury over to their side. And when you say talking objections, so there's two reasons why you're doing that. Number one is that you want to cue the witness in on what you really want the witness to say, or what direction you want the witness to go with their testimony. So you may not, if you just say objection relevancy, or if you say objection, that this witness cannot possibly know that information, or the jury, you're asking for speculation, calls for speculation, things like that. So then you're actually letting the witness know, hey, listen to me. I'm telling you that you're about to speculate, and I don't want you to speculate as my witness. So you're also letting the witness know when you talk during your objections what your problem is, because in the event that the judge may overrule your objection, you still want your words, the witness to hear your words, and then the witness will start thinking a little bit more carefully about their answers. So that's another reason why you want to object. And not just object, but another reason why you want to give more of a long-winded objection, to speak with your objections and say more words, more sentences, so that the witness can listen to you and hear especially if it's your witness, what you're going at here. That's another reason. But there's another reason also. The other reason that you want a speaking objection is because, again, we're always trying to win the jury over to our side. As a lawyer, you're not just putting on your case in front of the jury and saying, jury, you figure it out. You're trying to win the jury over. You're trying to win credibility with them. You're trying to score points with them. And part of that is to show them that you're the good guy and they're the bad guy. And by explaining your position, why you're making this objection, and you're showing the jury by speaking, because they don't know the rules of evidence. They don't know that, and really they're supposed to tune all this out, but they're not tuning it out because they're sitting right there. So they're hearing everything that's going on. So you want them to hear what you're saying, and you don't want to look like a jerk who's objecting. So you want to make it look like you're forced to object. I'm forcing to object to this question because they're doing something unfair. That's what you want to get across to the jury. And therefore, and the other side is going to respond in kind because they want to win the jury over to their side. So if you think about it, what happened in here, in this case, is that the prosecution is trying to very slyly get in front of this jury that there was some nefarious conduct going on. I mean, maybe not call it nefarious, but there was some sneaky stuff going on over the lunch break when they were discussing this testimony. Now, of course, there's a jury instruction that tells the jury that there's nothing wrong with lawyers talking to witnesses. They're allowed to do that. And even if it's brought out during direct or cross-examination, that's completely fine. But again, how much are juries paying attention to the jury instructions? So as the prosecution gets up and talks about, oh, this is the article that you spoke about with the defense counsel over lunch, and just throwing it in there, the defense is not going to just take that sitting down. So the defense gets up there and says, we didn't speak about this during lunch, did we? And now the prosecution looks bad. Now the prosecution is in front of a jury. They don't want to look bad in front of the jury. So therefore, they're going to respond and say, "Hey, this is an exhibit. This is an admitted exhibit. This is your exhibit. So don't try to pretend like you don't even know what this exhibit is." So that's really, I think, what was going on there. It's a lot deeper than what it just looks to the naked eye, to the untrained eye. That's really what's going on there. And the judge just wanted to put an end to it. The judge didn't want this to go on. So the judge stopped, excused the jury, and said, we're not having speaking objections because she doesn't want all this. And apparently she's also familiar enough with the rules. And again, she said that she doesn't want the rule number to be just said to her, but she suggested that you could say the statements that go along with that rule, like what the rule is, like relevancy and hearsay, things like that, she was okay with them saying, but speaking objections when you're actually talking about your objection and why you're making objection, she doesn't want any of this, she doesn't want any of these games being played. So I thought that this was a very interesting clip, and very informative, and it gives you a lot of insight into really what goes on during jury trials. Okay, so that's it for today, and we will see you next time. If you haven't yet, please subscribe and like the video so we can continue growing. See you next time.